Okay, and with that, we will call now our second case of the call, Molitoris versus St. Mary Magdalen Catholic Church. This is a mini oral argument on the application. So 15 minutes per side. Ms. Goldman, if you would like to reserve any time for rebuttal.
I reserve 2 minutes.
Okay, we just ask that you try and keep track of that yourself. Obviously, as you're well aware, there's a 2-minute fire-free zone, which you may waive. And with that, please proceed.
Okay, Barbara Goldman here on behalf of the appellant. I'll just make 2 points while I have the opportunity. The first is, if you do adopt the third restatement, this is really not a tectonic shift in Michigan premises law the way it's sort of been characterized by the defense. It integrates with our system of comparative negligence, and all of the defenses that have ever been available on a premises case are still there. The plaintiff still has to establish notice. Open and obvious is available as it's no longer an element of duty, but is available as a defense. Foreseeability, proximate cause, wrongful conduct is a defense. We have statutory defenses, intoxication, commission of a felony. And the legislature has thoughtfully codified for us the attractive nuisance doctrine. The other side is that adopting a single reasonable care standard will actually benefit landowners in some situations. The standard now that is inspect and correct is actually higher. So another advantage is that a homeowner, for example, or somebody who's not ordinarily having business invitees won't get caught by the heightened standard for an invitee if they have something like a garage sale or a realtor come to review their house. And also keep in mind that the court is already having to apply a standard of reasonable care in situations like when the plaintiff is pleading something other than premises liability. We saw lots and lots of those before before Candle El Sayed, because the plaintiffs would try to say that we don't have a premises case, we have something else. I have other points I could make, but I think I will leave this to you to ask questions.
Counsel, I would love to talk a little more about how this would work. So if we were to agree with you that the third restatement is the proper way to go, my understanding is there's pretty much always an assumed duty by a landowner. It's just sort of a given. Do you agree with that? I mean, there's...
I'm having a little trouble picking up what you're saying.
So would you agree that under the third restatement,
right,
duty, pretty much every landowner owes a duty? Is that correct?
Right. The same level of duty is owed to everybody except a trespass.
Okay. So then if something goes wrong on the land, that potentially goes to breach. So that's the second part of the test. So would motions under C8 ever be able to be granted, or would everything get moved to C10? Does everything get to a jury? What is if there's sort of we'll call it a frivolous lawsuit or something, can anything get kicked at C8?
Well, that's what I was just saying. All available defenses are still available, and some of them would be C8 defenses. Certainly if you could establish trespass, that would be a C8 defense. If you could establish a statutory defense under the felony or intoxication law, probably the majority of them would be C10s, but that's the way it is now. I mean, I can't remember how many cases I've litigated where there was a summary disposition under C8. It's probably that many.
Thank you.
So as I was saying, this doesn't open the floodgates. It just changes the standard. There will be, well, I'll leave it at that.
So I'm wondering about sort of homeowners, private property owners, and I'm just wondering, I understand the challenge to STIT and the sort of invitee and licensee distinction, which is carried through to this case. But obviously, we have to think about the big picture. So the third restatement, obviously, it seems to me it would be a dramatic shift as to homeowners. Tell me why that, if you agree or disagree.
I'm still having a little trouble with the mic there. Are you saying that the standard would or would not benefit?
Not a business.
Non-business.
Somebody's private property.
Well, I don't think it would make a lot of difference now. The one thing that I think would really be important is what I was saying before. You wouldn't inadvertently get caught by the invitee standard if you're if you're not a business owner. And if you think about it, the majority of premises cases really are cases against businesses, but I've felt great empathy for the homeowner who got stuck with somebody who tripped over a gopher hole because they were having a yard sale. I haven't had a yard sale in a long time. I don't know, does that respond to
fair
your
enough.
question?
Thank you.
Yeah, this is probably the biggest change, would be what it would do for homeowners who got into that sort of situation. And it would simplify things. I mean, look at how many different exceptions that have had to work out. Premises liability goes back, I wouldn't want to say how many centuries, but a number of centuries. And okay, it was simple when we started. No duty to trespassers, duty to people who are there because you want them to spend money. And that just got more and more complicated. Well, we had to have this exception and that one and create this one. And that was what STIT was about, partly, was the whether Michigan should accept public invitee as yet another classification.
Well, that's my question, is I understand your position. Is it a question that we would adopt the third restatement that eliminates a distinction between invitees and licensees? Or is a more reasoned step to reevaluate whether or not STIT was correct in defining what in fact is an invitee? Is the problem with the existence of these distinctions, or is it with how our common law has defined what an invitee is?
I would go with the first one. I think the problem is that the categorization system has become too complicated. We would disagree with the rather narrow definition of invitee that's in STIT, but I don't think that simply overruling that would address the issue of the multiple categories and the amount of time that courts and attorneys spend on trying to decide which category a particular plaintiff falls in.
So moving off the question a little bit of the category of entrant onto the land, let's just say, are you asking us to adopt the third restatement in total, meaning another important distinction, which we have reaffirmed recently in I'll say Ed, is, the third restatement would just say that any risk is submitted, to the jury, and Michigan has always defined the duty in terms of an unreasonable risk of harm. And I think the third restatement says, let's put that question of reasonability or, reason or unreasonable as a fact question for the jury. And so is your argument limited to just the category of entrance as opposed to changing or adopting the third restatement in total?
Well, this court can do whatever it wants to. What the third restatement did was say there's just one standard of care for anybody who's on the land except for trespasser. And that we would, I think that would be what we would advocate for, rather than changing the duty that is owed to any particular class of entrance. The third restatement has, subsection A is flagrant trespassers, and the rest of it is natural, unnatural, any condition, reasonable care.
So, getting back to my private property owner question, a homeowner, they go away for the winter, they have neighbors, they're really close friends, the neighbor, there's a big snowstorm, and the neighbor there are trees down, and the neighbor decides to be helpful and go in the backyard to check on the trees. And there's a bunch of equipment that got covered up by the snow, and obviously you left, you didn't think anything about your fall rake you left out, whatever. What happens in that lawsuit?
Well, you got two things there. One is if there's an exception for trespassers, which the third
Yeah,
is,
and let's just assume they're not a trespasser. They do
Okay,
have permission
all right.
to come on the property.
then the question becomes what's reasonable. And don't forget that the plaintiff's lawyer has a part in this. A plaintiff's lawyer faced with those facts might very well say, I'm really not going to be able to convince a jury that there was a duty to the neighbors. Remember, this is another thing I was saying before, foreseeability is still, we would still have to establish that. Well, how foreseeable is it that a tree is going to come down when it's snowing and there's a rake under there? It's 'cause you could possibly still get summary disposition, although it would depend on the facts and the judge.
And that, I would assume, would be at the C10 stage, because
Yes.
you have to do discovery and.
Well, as I said, most summary dispositions either are C10s or they're C8 and C10 because you really can't tease them apart. I mean, you still need to develop a factual record, no matter what if we retain the three-part classification, you still have a factual record in order to get a case dismissed or to allow it to proceed.
Could a C8 motion be based on the argument that the risk of harm was not unreasonable?
I think you could make that argument.
Say like a curb, right? A curb presents a risk of harm, but there's a utility to having a curb. And it's just a plain ordinary curb. Could that be kicked on, there is no unreasonable risk of harm?
Well, the defense would argue that there's no way that could be unreasonable. And again, it would depend on the facts. Most of the time, we have a long line of cases saying things like stairs, if they're not, if they're in compliance with the building code, are not unreasonable. I had a case once where somebody said, well, the room was too small. That you really couldn't make an argument on that. So again, remember that the plaintiff's lawyers are the ones who are initiating the cases. The plaintiff's lawyer is taking a chance. The plaintiff's lawyer goes too far out in the outfield, they're not going to be able to get anything for the client or themselves. I guess those cover the points that I was planning to make, unless you want me to address the Robinson factors instead.
You can do that. You have about 2 minutes and 15 seconds if you'd like to say that.
2 minutes and 16 seconds. Okay, I'll just plop through that quickly. As Justice Kavanaugh and I were talking about, what Stitt did was make a narrow definition of invitee, and it also decided we won't adopt public invitee as the only state in the country at the time that did not. And therefore, the question of wrongly decided really isn't dispositive here because there wasn't a decision. What Stitt did was readopt, you might say, the three-part classification that had been in effect since, as the gentleman before me described, the history of the Michigan Supreme Court, which sounds like it was kind of fun back then. We discussed practical reliability. That's what's in my brief. And the court has certainly signaled to the bar that it might be adopting the third restatement, so it should not come as a shock.
Thank you.
Good morning, Your Honors. Tom Maher for Appellee St. Mary Magdalen Catholic Church. May it please the court. I intend to make 3 points today, and I definitely want to pick up on the questions that I just heard and other questions that are asked. I think it will be a better way to address these issues more fully. The points are that the third restatement, Section 51, is contrary to the way this court has analyzed duty from the beginning. The second point is that if you choose to overrule Stitt, as was the second question that you asked us to brief, you're going to be doing a lot more than overruling Stitt. And I think you have to be careful about trying to just say, we're just addressing this specific fact situation in Stitt. I think that will get into the question of whether, if you're going to take this huge societal change, and it is one, whether that's better left for the legislature. And the third point is that this simply is not the right case to take on issues like this. In this case, the plaintiff has admitted that the church had no reason to know of any risk, did not know and had no reason to know of any risk. This case, if it's sent back on remand, will end up with the same result. So I think you picked the right case. You know this better than I do, and I think this is not the right case. Going to the first point about duty, it has for many, many years been the case that premises liability and negligence cases require the plaintiff to prove duty, breach, causation, and harm. Starting with duty. Duty is a question of law. Duty is a C8 motion. Duty is what defendants in trial do. We come to the court and say we should go no further. As a matter of law, this case should be dismissed because no duty is owed. And there are plenty of cases where I've done that and my colleagues have done it, and the case has properly been dismissed and years of litigation have been avoided. Duty is a question of law, and it has always been a question of law. And to address that question of law, you have to address several factors. This court consistently has said, look at the relationship of the parties, the foreseeability of the harm, the certainty of the risk that's involved, the moral blame, the burdens on the defendants were you to impose a duty. These factors are addressed in all of your duty cases, but not under the third restatement. Under the third restatement, the only factor is whether someone has entered land. And these are the questions, Justice Wellesley, you actually were asking. Is that it? You enter the land and a C8 motion is not possible. That's my reading. You've entered the land, therefore there's a duty of reasonable care, end of case. We're not going to look at all those factors that according to your authorities say you must look at. You must analyze these factors, and it is a question of law.
Counsel, what do we do about sort of the odd result in this case, black ice aside, and whether that was known or not? This sort of oddity where if someone who is selling vegetables to the church, obviously would be covered, but plaintiff here isn't. It does seem to be an odd result when the church already sort of has an obligation to make sure it's taking care of other members of the public coming in.
I agree with you. There are all sorts of oddities. There are all sorts of difficulties. It's a broad range of cases over hundreds of years. There are thousands of cases that have come to court on premises liability claims. And there are the oddities. There are the anomalies.
I mean, I guess I'm just wondering, I know under Stitt, the court decided to not adopt sort of the open to the public definition of invitee, and I'm just wondering if that was the right choice for the court to make at that time.
The public invitee choice of the Stitt court?
Yeah, whether if it's just open to the public, then we don't get into all the different reasons why they're there, they're invitees.
I would not agree with that approach. I think that our society has always differed businesses who are making money on your being there from volunteer organizations like I represent or from homeowners like you mentioned in your examples. There's good reason to separate homeowners and volunteer organizations who are serving society without pay from those who receive pay. I think it's a fair quid pro quo to say to a business, if you're going to get money because they're parking in your parking lot or they're coming to your store, you owe an obligation to make sure it's safe. It's a very different situation to have that carry over to the neighbor who tries to be a good neighbor and take care of the problem, and now all of a sudden they're sued. And it is a remarkable thing to be sued It takes a long time to go through a lawsuit. There are huge costs that have nothing to do with money. And I know that because more than anything else, I'm a trial lawyer. I'm not an appellate lawyer.
Can you tell me, I mean, I understand one of your arguments of why this court should not change the common law in this regard is, like you're saying, the burden of, I guess, surviving CH, or the burden of having to go to a jury or having a jury decide reasonableness in this. Is there some unique, I don't know, for lack of a better word, frailty to premises liability cases? Because negligence cases, malpractice cases, I mean, we trust juries, you know, some survive C8, some don't. We trust juries to make reasonableness findings or evaluate standards of ordinary care or even more burdensome standards all the time. What is it unique about premises liability that we should be cautious about allowing juries to decide those issues?
I trust juries too. Juries should decide a lot of issues. Juries should decide whether someone has exercised reasonable care. The question is, did this defendant have the duty to exercise any care? The difference in a premises case is that the general rule in negligence is there's no duty to protect. Premises is an exception to the general rule. We are requiring you to protect. It is an exception to the no duty to protect rule. And in requiring you to do that, here are the parameters, here are the contours. Here's why in this circumstance with someone coming onto your land, you now have an affirmative duty to protect. Maybe to inspect, maybe to warn, maybe to repair a defect. But it's because of this relationship between the landowner and the plaintiff that we impose a duty that otherwise would not exist. And I think it's very important when we talk about STIP, when we talk about how do you define licensee invitee, to recognize the relationship is the touchstone for all duty. And the homeowner and the volunteer organizations stand in a very different relationship with the people on their land than does the business owner. That's why we treat them differently. The general notion of why do we treat premises differently than negligence is because premises is an exception to the rule that there's no duty to protect.
Counselor, we've had submissions about, the range of ways that states have approached this question. And some states have not wholesale adopted the restatement, but have done sort of hybrid things. And the one that I wanted to get your insight into, some have, for example, eliminated the distinction between invitee and licensee, but continue to look at the kind of factors that we have historically looked at, so relationships of the parties and things like that. So it's just the categorical distinctions that they've eliminated. And I'm curious what you think about that approach.
I think it's an interesting approach. I don't know how it works in practice, how you can say that there's no difference between an invitee and a licensee. We're not going to wade into that anymore. But we, the judge, looking at a C8 motion, is somehow going to say, looking at this relationship, which, by the way, is a homeowner as compared to a business, I mean, I just don't know the logistics of that. I almost feel like we're giving lip service to a change that I'm not sure how your circuit court judges in this state are guided.
Yeah, so imagine, I think the homeowner with the yard sale, maybe we would, you wouldn't say, oh, that's this box versus that box, but you would say it's homeowner, and so we're going to have a different kind of standard of duty there than we might for, a business that's.
Again,
I don't know, right? I'm just asking what you think of it, because I saw it out there and I thought it was interesting.
No, I appreciate it, and I think that when I look at the other states that have adopted the third restatement, I think the ones that at least have only done so in part make more sense. That certainly you leave trespassers out of this equation, and whatever flagrant trespasser is. But when you get into the question of, don't we just include licensees and invitees as a single category, and then somehow take the factors that the court has always required and ask the circuit court judges to say, apply those factors to all these people because there's been an entrant on land who was not a trespasser. I think that's a mistake. I think we have to continue to recognize that there are certain groups that society wants to protect. We want to as a very practical matter. And the comments in the restatement talk about it. They talk about the social norms of treating homeowners differently than businesses. They even give examples of when homeowners have people over to entertain them and they serve them alcohol. Those homeowners should be treated differently than a business establishment that serves alcohol. This is the restatement comment, because of the social norms. And so there are societal reasons that we've treated licensees differently than invitees.
Would you
And I don't
agree
think
that
that
whether
should
it's a
change.
commercial property or a residential property, you will have and will have to do some level of fact-finding to figure out whether in fact they're a licensee or an invitee? I mean, had Mrs. Molitoris decided to do exactly what she did but wanted to drop off her donation to the church, what is that? Like it's not this, it's a question of nothing will ever go to C8 again, or we'll never be able to, everything will now take years and go to a jury and all of that. This distinction between commercial property and residential property, I mean, residences can have invitees on their premises as well. And I understand your point. It is a change. I think you said it was a huge societal change. I wonder sometimes if we're in our sort of legal bubble where it's a huge change in our world, but for the people who are homeowners or business owners or business visitors or home visitors, is it in fact a change in how somebody addresses issues on their property, or what somebody expects to be the level of care that's used when they go onto somebody else's property?
I think it's a good question. I think it's a huge change for this reason. The reality is that if the third restatement, my reality as a trial lawyer, if the third restatement is adopted, every time somebody enters land and gets hurt, the letters are going to go out. And eventually, no matter what one thinks about the insurance industry, insurance rates are going to go up. And eventually, people like St. Mary Magdalen Church or shelters or food banks are going to find insurance to be cost prohibitive and are going to say, we're not going to do this anymore. It's just not worth it. Are we in the legal bubble of saying that, the homeowners aren't going to act any differently, the companies aren't going to act any differently? I think there's a lot to that, Judge. I also think that understand that it's a duty is a question of law, but there are sometimes it's not. Sometimes there's a question about whether the risk was foreseeable. Sometimes a jury has to decide, licensee or invitee. That's why the jury instructions have definitions. If you find that they're a licensee, this. If you find that they're a invitee, this. So a judge may find himself in a position of saying, I can't rule as a matter of law because there's a fact question that underlies the issue of duty. I do think that in the main, thousands of cases are resolved based under the current system. And that it's only certain cases that go up to the jury and certain cases where you really have this, that doesn't make any sense, staring us in the face.
Counsel, you noted about that the distinctions are about, protecting certain categories of folks, agree. I'm still troubled. What do we do about if it's just open to the public? Why would we historically say that someone who walks in to run the cash register at a nonprofit that sells discounted items versus the volunteer who comes in to run the cash register, what would be the reason to treat them differently? Again, I'm just asking, it's this open to the public issue that I'm struggling with.
Let me see if I do understand, Justice, excuse me. Churches are open to the public. Food shelters are open to the public. People can come in and take the benefits of these organizations. If someone comes in and decides to transact business in the church in some way, why wouldn't that person then become an invitee, if I'm understanding your question, or why are they being treated differently when in fact it was open to the public? Do I understand your question?
Yeah, I'm thinking of, there's lots of nonprofits that sell items as part of their business model. They're a retail operation, right?
I understand.
but they also have volunteers who come in and do, frankly, the same thing that the people that are paid by that entity to do. So they're treated differently. It is sort of,
I do understand it,
Yeah.
and it is the case that those cases have come up, and that courts at times have said, in this context, this was an invitee relationship. And courts otherwise have said that, no, this is a volunteer organization, might be open to the public, but that's for non-business purposes, so they're a licensor. I haven't given you a broad answer to your question, but I'm telling you that, of course, those cases come up, and they will come up. The big question for a court like this and for the legislature is, overall, what should the rule be? And if you're going to change the rules that have been around for an awful long time, I do hope that part of the equation will be, is this one where we defer to the legislature? Is this one, as we did in the Recreational Land Use Act, as we did in the Trespasser Liability Act? These are legislative choices that we're going to limit liability in those circumstances because of the social policies that they analyzed. So if you're going to change the circumstances that have been in existence for all this time regarding premises liability, that's a big change. Maybe it's for this court, but I do appreciate in hearing comments where, at a minimum, you wouldn't go the third restatement route. That I just can't, that I think would be a mistake.
In Price versus High Point Oil back in 2011, the defendant went to a house they weren't authorized to go to and put filled oil into the home. There was no container, they'd switched, and they filled the basement with oil, causing great damage. And plaintiffs made it to our court asking for non-economic damages, and the court unanimously declined to change the common law because we held that such a fundamental change in the common law was unwarranted. Change in the common law must come incrementally. And what I'm having trouble analyzing here, is this a question of whether Stitt was rightly or wrongly decided, or is this a question of whether we are going to make a fundamental change in our common law such that we ought to look at it through the lens of Price versus High Point Oil?
I appreciate the question. It's you know, I don't know what the answer is. I don't know if the whole issue here is, should Stitt be reversed? Then the issue is exactly what Justice Kavanaugh said. Are we talking about the distinctions themselves or how the different categories are defined? Because Stitt talks about, I view this as a licensee, I view this as an invitor. If really we're just focused on Stitt, that's one thing. But the questions we've been asked to brief, of course, are much broader than that. So I'm not sure, Justice Czar, if that's what's at issue, just reversing Stitt, saying that it improperly defined who's a licensee and an invitee, or is it something far broader than that, and that is adopting the third restatement?
Thank you. And I will note, Justice Czar, I think Price versus High Point was expertly argued by the defendant.
That was you?
That was me. Put that plug in there. Thank you, Mr. Maher, I appreciate it.
Thank you, Your Honors. Any other questions? Thank you.
Ms. Goldman, you have 1 minute and 5 seconds for rebuttal.
Just, excuse me, quickly, the C8 versus C10, when I said C10, I'm thinking of going outside the pleading. So yes, it could be a C8 motion, but with a factual record. Counselor has very kindly made the argument of the enhanced duty to invitees, which is exactly what I'm saying. If you adopt a single uniform standard, actually would be lower. It may benefit businesses. And as for the
I'm surprised the Chamber of
insurance,
Commerce didn't hire you to argue for them.
pardon?
I'm surprised the Chamber of Commerce didn't hire you to argue for them.
And as for the insurance always comes up. I have had the opportunity to look at insurance for nonprofit agencies. Think of the fact that you still have exactly the kind of risk that we've been talking about here. Insurance is still going to have to accommodate the fact that some people are going to be invitees, even if we retain, or they do have to, and under the current insurance, so that cost are probably not going to be that different.
Excellent timing. Thank you. The case will be submitted.